Hello, hello, hello! Welcome, 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 welcome! Hi, Wawa. Hi, JJ. Hi, Fishy. Hello, hello. I am doing well. I am doing well. Much better than yesterday. That is for sure. Hello, hello, hello. Yes, my ear is still hurting. I mean, I just had it cut up, so of course it's still hurting, but it hurts much less than yesterday. I was able to get, like, the blood and stuff out of it when I took a shower this morning. I was finally able to take a shower. I'm so happy. It was so stinky. It was so stinky. But I did not go to work today. Instead, I did my civic duty and I voted, and then I got Starbucks as a treat, as a small treat. No more stinky yippee. Yes, no more stinky fish. No more stinky fish. But yes, I voted and I got Starbucks and I worked on some streaming stuff. And now we're here. Now we're here. Now we're here. Now we're here. And I am excited. I got my hands on the not Court of Appeals, the South Carolina Supreme Court ruling in the Alec Murdaugh case, South Carolina versus Alec Murdaugh. So I figured we could look at that tonight before we play some video games and just chill. I was able to get out of work today. Not gonna be able to get out of work tomorrow. I have no more time off. I cannot take any more sick days. Because this was my last sick day that I could take. And damn, was it worth it. It was so worth it. So glad I took the day off. I am so tired. Saturday work, I have overtime. We have a big project going on at my office, so I've been coming in on Saturdays to get some overtime. Am I looking forward to it? No. No. It doesn't mean that I will turn down free money. Well, it's not free money. I have to actively put in labor for it, but... As long as you get paid, I guess. Yes, I like money. But they're probably gonna be ending. They're probably going to be ending our overtime soon because we're going over budget with it. Too many people are taking overtime. So I'm trying to get what I can when I can. Because I don't make a lot of money. I don't make a lot of money. So anything to give me more money, I will do. Well, most anything. No, I'd probably do anything. I'd probably do anything to get more money. But yeah. As long as I get paid, as long as I can put food on the table, and, well, not even that, as long as I can pay my bills and I don't get kicked out of my fucking house, then I'll do whatever it takes. But, yes, soon. But I wanted to stream earlier today, because I really don't have anything else to do other than stream. Well, I do have other things I need to do, but I prefer streaming, so I'm gonna do those instead. Yawning still hurts, though. Yawning does still hurt, which sucks, because I keep fucking yawning. I keep yawning. Let me see. Where did I put that document? I downloaded it earlier. I downloaded it and made sure I had it, but now I don't remember. I don't remember where I downloaded it to. Dova, hello! Hello, Dova! Welcome in. I was just telling everyone what we're doing today. What we are doing today. Alright, where did I put that? Where did I put that? Ah, here we go. Here we go. Switch to the correct screen. Move. Nope, stop that. Stop that. Move OBS over here so it looks like my model is reading the document. So when I look at chat, I look down at chat and I look up at the document. Alright, so, State of South Carolina in the Supreme Court, on the appeal of Richard Alexander Murdaugh. Alec Murdaugh, however you want to say it. It was appealed from the trial court, which was Judge Newman, the post-trial court, which was Judge Toll. And the outcome of this is that it was reversed and remanded. That means that the trial court and the post-trial court made decisions that the Supreme Court does not agree with, and they do not believe follow the law. So they reversed those decisions, meaning Alec Murdaugh had filed a motion for new trial. That motion was denied. And so the Supreme Court is sending it back down to the trial court and saying, you got to do this again. He gets his new trial. So that's where we are in the proceedings. In the first bit of this, the per curiam gives like the background of the history of this case. Well, no, not the per curiam does, but part 1, factual and procedural background does. But so, per curiam. For 6 weeks in early 2023, the eyes of the nation focused on Colton County, where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife Maggie and son Paul. Both the state and Murdaugh's defense skillfully presented their cases to the jury as the trial court deftly presided over this complicated and high-profile matter. However, their efforts were in vain because the Colton County Clerk of Court, Rebecca Hill, placed her fingers on the scales of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. Our justice system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury untainted by external forces bent on influencing the jury towards a biased verdict. Although we are aware of the time, money, and effort expended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for new trial due to Hill's improper external influence on the jury and remand for a new trial. Because we order a new trial on this basis, it is not necessary that we review every evidentiary issue Murdaugh raised on appeal from his conviction. However, we address the admissibility of Murdaugh's financial crimes to offer guidance on this thorny issue to the trial court on remand. So this basically gives us an overview of what they're going to talk about, right? So they find that the clerk of court, Becky Hill, improperly influenced the jury to think that Alec Murdaugh was guilty. 2, they find that he does deserve a new trial, and the denial of that new trial was not correct, so he's getting a new trial. And 3rd, a lot of Murdaugh's financial crimes came in to the original trial. And while they're not giving any rulings on those financial crimes and their admissibility, they are going to give guidance on how the law states that they should be handled. So this isn't saying that oh, the attorneys were horrible or the judges were horrible or anything like that. It's saying that there were errors made by an outside force, and that is the reason for the new trial. The outside force being Rebecca Hill, who was the clerk of court. And we'll get more into that in the factual and procedural background after I take a sip of water. I love this new Starbucks cup I got. It's so huge. It is so heavy. I could like beat a person to death with it. I love it so much. All right. And here's where we get into the background. On March 2nd, 2023, Murdaugh was convicted of the murder of his wife, Margaret Murdaugh, and his son, Paul Murdaugh, as well as 2 counts of possession of a weapon during the commission of a violent crime, guns, firearms. The trial court, Judge Newman, sentenced him to life in prison. And during the sentencing, Judge Newman basically was like, I hope you think about what you did for the rest of your life. You'll have a lot of time to think about it behind bars, mister. Maybe we should watch that sentencing sometime. It was very, well, no, we shouldn't watch it. We shouldn't watch it because now it's been remanded for a retrial. So we'll wait until the retrial to see how it goes. While his direct appeal of these convictions were pending at the Court of Appeals, Murdaugh filed a motion to hold the appeal in abeyance and allow him to file a motion for new trial. The Court of Appeals granted this motion. Holding in abeyance just means, like, can we put a pause on it? Like, oops, stop. We're going to take a second, we're going to pause, we're going to time out on the appeal because we want to file a motion for new trial. The Court of Appeals granted it on October 27, 2023. Murdaugh moved for a new trial, asserting Hill tampered with the jury by 1, advising it not to believe Murdaugh's testimony and other defense evidence, 2, pressuring it to reach a quick guilty verdict, and 3, misrepresenting information to the trial court in an attempt to have the court remove a juror she believed favored the defense. He attached affidavits from several jurors in support of his motion. Chief Justice Beatty appointed former Chief Justice Toll, who was the post-trial court, the second judge, to preside over this motion as the trial court judge had recused himself. So since there were issues dealing with the trial court judge said, another judge needs to handle this. It would not be right for me to preside over this motion for new trial again because I had already denied it. So it went to Justice Toll, who is a wonderful, delightful lady, might I add. Just wonderful. And also, like, this whole case, this whole trial, and the motion for new trial, and the appeal, like, I've watched all of it, okay? I've watched all of this shit. And it has been so interesting just to see the legal process completely play out, because normally you'll have a conviction, you'll have a motion for new trial, that typically gets denied. There will be an appeal of the conviction, and that appeal can take years, like years, to go through, especially on like big cases. And you can have multiple appeals at the same time. But this one was very quick. The Superior Court directly took it from the Court of Appeals because they wanted to rule on it. So it went very quickly, like I said, on March 23rd was the conviction. In October of that same year was when they went to have the motion for new trial. So this has moved very, very quickly. This has moved very quickly through the legal system. And for good reason. The post-trial court conducted the hearing of this motion on January 26th and 29th, 2024. During the hearing, the post-trial court asked each juror, 1, if the guilty verdict was an accurate statement about their verdict at the time, 2, whether their verdict was based entirely on testimony, evidence, and law presented in this case, and 3, whether they heard Hill make any comment about the case before their verdict, 4, whether their verdict was influenced in any way by communications from Hill. And again, Hill was the clerk of court, Rebecca Hill. So, I realize here that people might not know what a clerk of court is. So, a clerk of court, the clerk's office are the record keepers of the court. They keep all the documents, evidence, and like letters, things like that, filed with the court. So, entries of appearance, motions, leaves of evidences, indictments, accusations. They're the record keepers. They keep all the paperwork, right? And the clerk of court is the head of that office, the head of the clerk's office. So she's in charge of dealing with like the grand jury, and I believe in this county in running jury trials. So like keeping track of jurors, making sure all jurors are present, making sure nothing happens to the jurors, stuff like that. So it is a very influential and important position to be impartial in. And of course, we're getting into the fact that she absolutely fucking wasn't. She absolutely wasn't. Juror X, who testified on the first day of the hearing, acknowledged hearing Hill say before Murdaugh's testimony, quote, "It looks like the defendant is going to testify. This is an important day," or "this is an epic day." One of those two. And that it was rare for a defendant to testify. Juror X said these statements did not impact their verdict. And that is true. It is rare for defendants to take the stand in their own defense. Like, a lot of times, attorneys are like, you really shouldn't do this. You really should not. But he did testify in this case. And that's his right. He absolutely has a constitutional right to face his accusers and to testify. There is nothing one way or another about a defendant choosing to testify. The content of that testimony should be considered, but whether or not they do or don't testify should not be. It can't be held against them. Juror Z, who submitted one of the affidavits Murdaugh attached to his motion for a new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about this case, Juror Z responded that Hill said to, quote, "watch his actions," and, quote, "watch him closely." Juror Z added that Hill said more, but she could not remember anything else. Juror Z explained Hill's statements influenced her finding Murdaugh guilty because, quote, "to me, it felt like she made it seem like he was already guilty." At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn. Juror Z's affidavit gave a more detailed recitation of Hill's comments. Quote, "Toward the end of the trial, after the President's Day break but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury to not be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. She also instructed the jury to watch him closely immediately before he testified, including to look at his actions and look at his movements, which I understood to mean he was guilty." End quote. Juror Z testified that when the jury began deliberations, Hill told the jury, quote, "This shouldn't take us long." In addition to referencing Hill's statements, Juror Z averred in her affidavit, quote, "I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by other jurors." End quote. Hi, Valley! Greetings from Asen. Greetings from Iriam. I hope you guys are having fun. Juror Z testified that when the jury began deliberations... Oh, wait, I already read that. Sorry. After reviewing the affidavit, the post-trial court questioned Juror Z. "I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is, quote, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by other jurors. Is that answer that I just read a more accurate statement of how you felt? Juror Z answered affirmatively. The post-trial court then asked if she stood by the affidavit, and she answered yes. Juror Z subsequently submitted an affidavit to clarify her testimony, in which she explained that she felt influenced to find Murdaugh guilty by Hill's remarks before she entered the jury room, and once deliberations began, she felt additional pressure from the other jurors to reach a guilty verdict. Although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court. Water. You guys better hydrate too. Juror P testified that on the day Murdaugh was to take the stand, Hill made a comment to, quote, watch his body language. Hill denied comments influenced him in any way. And there's a footnote. The remaining jurors testified that they did not hear Hill make any comments about this case, and they were not influenced by any comments Hill made. Footnote 1. Following Juror Z's testimony, the post-trial court informed the parties that the other jurors who were waiting for their turn to testify had turned on the proceeding on court TV. The jurors denied either viewing the proceeding, or if they saw it, asserted that it would not influence their testimony. So this whole thing, like from start to end, this whole thing is just fucky-wucky. Just all the things. Following the juror's testimony, the state called Hill as a witness. Although Hill denied making most of the comments the jurors related, she admitted that on the day Murdaugh testified and within earshot of some jurors, she spoke to a bailiff about Murdaugh's decision to testify. She also stated that she gave the jurors a little talk, instructing them to pay attention and that the day was a big day. She denied attempting to influence the jury. In discussing her book, Behind the Doors of Justice, The Murdaugh Murders, footnote 2, Hill claimed the literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial did not matter to her, but she acknowledged as true a passage in which she admitted she believed Murdaugh was guilty, but was concerned that he would be acquitted because of his family's goodwill in the community. So, side note, before we get to footnote 2, the Murdaughs were a very big family in Colton County, South Carolina. Lived there for generations, very wealthy, very influential, a lot of lawyers, people within the community, knew about the Murdaugh family. So when she is saying this, she's talking about how well known... No. Go away. Sorry, I just had a pop-up on my screen. But she was talking about how well known the family was. Footnote 2. As the book title suggests, it turns out Hill was quite busy behind the doors of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. The book was pulled from publication because Hill plagiarized portions of it. I love footnotes because judges get to be really snarky in them. And that's the most fun for me, is when judges get to be snarky, because I like to see it. Because a lot of times judges are very restrained and have a very judicial demeanor. But on things like this, and in things like when they talk to defendants at sentencing hearings, they get to speak their mind. They get to speak their mind, and a lot of times it's very snarky, and I love that. I love that for them. The post-trial court also questioned Hill about the favors she granted to media. Hill denied allowing the press to view the exhibits, including the sealed exhibits, which are never supposed to see the light of day. However, and get this, she subsequently pled guilty to perjury, stemming from this denial. Although the post-trial court limited discussion of juror 785, footnote 3, whom the trial court dismissed on the day deliberations began for allegedly discussing the case with third parties, it allowed Murdaugh to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed were from juror 785's ex-husband. Hill claimed that the juror was very talkative, while Hill walked her to the trial court's chambers and volunteered that there were restraining orders on her ex-husband when they divorced. In response to the post-trial court's questioning, Hill continued to deny initiating or engaging the juror in discussions of these matters. Don't talk to the jurors! Don't talk to the jurors! Don't talk to the jurors about anything! You should not have information about the jurors! just like, I don't care. Okay, this is a bit dramatic of me, but I don't care if you're gonna just talk about how blue the sky is. Don't talk to the jurors. Like, don't avoid even the hint, even the question, even the whiff of impropriety. Don't talk to fucking jurors. Like, I've seen a lot of courts give not an admonishment, but like a heads up to the jury before a trial begins, where they're like, hey, listen, no one is supposed to talk to you. And if you see attorneys or court staff, like, ignoring you, please don't be offended. They're just not supposed to talk to you. They're doing their jobs. So don't be offended if they don't, like, acknowledge you or speak to you, you know, more than a passing, like, oh, good morning, like, hello, excuse me, blah, blah, blah. Hello! Skullmorph, and Alita, Altio! Hello! I'm reading legal things. And drinking a lot of water because I'm very, very thirsty. Oh, fun. Yes, very fun. There was a lot of fucky-wucky going on in South Carolina. Footnote 3. When the trial court dismissed juror 785, she said her belongings left in the jury room included a dozen eggs, which another juror had brought her. She then became known as the egg juror or egg lady. I'm glad they included that. I'm so glad they included that she was called the egg lady. Oh, that makes me happy. But that's what she became known by the media as, was egg juror or egg lady, so that's why they're including it just, like, as a reference. In contrast to Hill's testimony, juror 785 averred at the hearing before the trial court, and in an affidavit Murdaugh attached to his motion for new trial, footnote 4, that Hill interrogated her about the social media post and whether she had been in contact with her ex-husband. In the affidavit, juror 785 related that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement officers questioned the ex-husband about the post, offering to reinstate restraining orders juror 785 had against him, and speculated that, quote, the Murdaughs probably got to the ex-husband when he called juror 785 on the morning of the verdict. Footnote 4, although the post-trial court did not allow juror 785 to testify, her affidavit is in the record for our consideration. Because appeals courts and the Supreme Court do look at the entire record. They don't just look at transcripts. Juror 785 asserted Hill asked her whether she and the other jurors were inclined to vote guilty or not, and told her that everything Murdaugh said had been lies. She also stated that before Murdaugh testified, Hill told the jurors to not be fooled by the evidence Murdaugh's attorneys presented. Remember how I said don't talk to the jurors? Definitely don't tell the jurors that the defendant's family probably influenced their abusive ex-husband to contact them despite restraining orders. Maybe don't do that. Maybe don't. Maybe just don't. Rebecca Hill, the woman you are. Now on probation for a very long time for pleading guilty to a bunch of shit. Rhonda McElveen, the Barnwell County Clerk of Court who assisted Hill with the trial, testified that Hill repeatedly told her she wanted to write a book so she could buy a lake house, and a guilty verdict would be the best way to sell books. McElveen testified that, after hearing Hill had given a juror a ride home, McElveen counseled her that it was inappropriate, and while Hill admitted she gave the jurors a ride, she claimed the bailiff was with them and that they did not discuss the case, footnote 5. Why just got probation? I don't know. I think she should be in jail, honestly, but they gave her probation. But the reason they're talking about another clerk of court coming in, McElveen from Barnwell County, coming in to help, this was a very big case. There was a lot of media involved. There were a lot of witnesses. It took 6 weeks. So they had another clerk of court come in to assist with the process because it was like a long and arduous process. Footnote 5, at the hearing, Hill denied giving the juror a ride home. Of course she did. Of course she denied it. Because, everyone else knows she did, but she's gonna deny it. She's gonna fucking deny it. Although McElveen did not hear Hill say anything inappropriate to the jurors, she stated that Hill made comments to her, staff, and media members strikingly similar to those Juror Z reported, such as advising them not to be fooled by Murdaugh's attorneys and to look at Murdaugh's actions and movements while he testified. Finally, McElveen testified that Hill seated a writer with court personnel. This writer wrote the foreword of Hill's book. Next, Murdaugh called the alternate juror to testify. She described the incident in which Hill made her comments before Murdaugh put up his case, stating that while the jurors were assembled in one of the 2 jury rooms or were standing in the hall, Hill stood at the doorway and told them, "They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off." The alternate juror also testified that Hill told the jurors not to be nervous and don't be afraid to show your emotions because that's what they want to see. The alternative juror related she heard a court staff member say deliberations should not take long, but she could not remember who said it. In its order, the post-trial court, so this is Justice Toll, the post-trial court, declared that the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. It then found Hill made improper comments to the jurors on the day Murdaugh testified. Example, "This is an important day," or "This is an epic day," and that they should watch Murdaugh's body language. The post-trial court determined Hill's denial of making these statements was not credible, finding Hill wanted to write a book, which she believed a guilty verdict would help sell. She was also, quote, attracted by the siren call of celebrity, and, quote, she allowed her desires for the public attention of the moment to overcome her duty to her oath of office and her oath as a witness. Hello, narrator. Welcome in. We're talking about legal stuff today because the South Carolina Supreme Court handed down its decision in the Murdaugh appeal. Next, the post-trial court found that these comments did not affect any juror's verdict. It explained Juror Z's assertions that Hill's comments affected her verdict were ambivalent, self-contradictory, and not credible, emphasizing Juror Z had acknowledged her statement in her affidavit that she had voted guilty due to pressure from other jurors, and that was the more accurate statement. The post-trial court further found that Hill's comments were limited in subject and not overt as to opinion, were only heard by, at most, 3 jurors, and were made in a case with overwhelming and compelling evidence, and that the trial court's extensive instructions cured any effect from these comments. The post-trial court concluded that while it found Murdaugh had failed to meet its burden to prove prejudice, any presumption of prejudice was overcome. It therefore denied Murdaugh's motion for new trial. Murdaugh timely appealed to the Court of Appeals. This court certified the appeal of the denial for a motion for new trial and subsequently consolidated it with the direct appeal. So remember, at first Murdaugh directly appealed, and then he asked for an abeyance, which means a pause, so he could file the motion for new trial. So when the denial of the motion went up on appeal, they just said, these two are the same thing. We're going to consolidate them and put them together so they'll travel together and we can address them both at one time. It helps things keep from being confusing, as if law wasn't already confusing enough. Part 2, Law and Analysis. So here is where we get into how and why the Supreme Court justices made their decision. Now, when something goes up on appeal to the Supreme Court, there is not just one judge deciding. There is a panel of judges who each, think about the case, come to an opinion, and then make deliberations about it. Subpart A, the Rimmer presumption of prejudice. Murdaugh argues he was denied his constitutional right to a fair trial by an impartial jury free from outside influences. He asserts that following Rimmer v. United States, prejudice should be presumed from Hill's comments to the jury and that the presumption is irrefutable. In the alternative, he contends the state failed to rebut the presumption of prejudice. And Rimmer, what they're talking about, Rimmer is a case that set the federal standard for jury tampering and a motion for new trial based on jury tampering. In the federal standard... Oh, hi, Sanic! Hi, Sinon! Welcome! But in the federal standard, prejudice is presumed. Like, if someone made comments to the jury, they're presumed to be prejudicial on a federal level. And it's up to the state, the prosecutors, to rebut that and say that it was not prejudicial and show that there wasn't any prejudice. In South Carolina, however, they have a different standard, where the burden is on the defendant to prove that they were prejudiced because there's no presumption. Mm-hmm. So it's two very different standards. Hi, Minnie, your tail is looking especially tasty today. Oh, thank you. I will take that as a compliment and not be creeped out by it that you want to seemingly eat my tail. I know, but it is especially plump and juicy today, is it not? Fish are tasty food. It's not weird. Anyway, the state argues the jury convicted Murdaugh because he was obviously guilty and not because 3 jurors heard Hill's foolish and fleeting comments about his upcoming testimony. It contends that the post-trial court correctly declined to presume prejudice, and any presumption of prejudice was rebuttable. But the Supreme Court here says we agree with Murdaugh, so they're reversing this decision. Prejudice is presumed from Hill's comments, and while this presumption is rebuttable, the state failed to overcome this presumption. Oh, keep reading, Minnie. They explain everything I said about the federal and state differences. Oopsie! I got ahead of myself. Our federal and state constitutions guarantee a criminal defendant the right to a fair trial by an impartial jury. Quote, no right touches more the heart of fairness in a trial than the right to an impartial jury. This right can be infringed when a third party makes improper contact with the jury, for the right is meaningful only if the jury remains free from outside influence, including exposure to evidence or information that has not been introduced during the trial, from State v. Green. To protect the right to an impartial jury in such cases, the Supreme Court of the United States created a rebuttable presumption of prejudice, which is the Rimmer presumption we talked about earlier, elucidating, quote, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial if not made in pursuance of known rules of the court and the instructions and directions of the court made during the trial with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily on the government, the state, to establish after notice to and hearing of the defendant that such contact with the jurors was harmless to the defendant. Anala, hello! My wonderful Kohai, welcome in, welcome in! We're talking about legal stuff today. The United States Court of Appeals for the Fourth Circuit noted that in addition to the presumption of prejudice, Rimmer established a separate but related requirement that a defendant be entitled to a hearing when the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury. The Fourth Circuit established a three-step test for considering extrajudicial contact with the jury, in that the party who is attacking the verdict bears the initial burden of introducing competent evidence that the extrajudicial comments or contacts were more than innocuous interventions. If this minimal standard, very low bar standard, is satisfied, then Rimmer presumption is triggered automatically. The burden then shifts to the prevailing party to prove that there exists no reasonable possibility that the jury's verdict was influenced by improper communication. I both love and hate when judges are long-winded. I love it because it gives me more information. I hate it because I have to read it. I have to read it. The Fourth Circuit further provided that in determining whether the extrajudicial contact was innocuous or whether it triggered the presumption, the court considers whether there was 1. Any private communication, 2. Any private contact, 3. Any tampering, 4. Direct or indirect with a juror during the trial, and 5. About the matter before the jury. The dilemma of info. Yes, the dilemma of info. So, the court has to look at whether there was a conversation privately, there was any private contact or tampering directly or indirectly with a juror during the trial about the matter before the jury. So it has to be about the matter before the jury, and it has to be direct, or it can be indirect. An unauthorized contact between a third party and a juror concerns the matter pending before the jury when it is of such character as to reasonably draw into question the integrity of the verdict. Once the Rimmer presumption is triggered, the state bears the heavy burden of proving there is no reasonable possibility that the verdict was affected by the contact. The court must examine the entire picture, including the factual circumstances and the impact on the juror. In determining whether the state met its burden in rebutting the Rimmer presumption, courts consider a variety of factors such as the extent of the improper communication, the extent to which the communication was discussed and considered by the jury, the type of information communicated, the timing of the exposure, and the strength of the state's case. Relevant factors to be considered in determining whether outside influences have affected the jury are the number of jurors exposed, the weight of the evidence properly before the jury, and the likelihood that curative measures were effective in reducing the prejudice. The extent of the communication is the most important factor. In Parker v. Gladden, the Supreme Court recognized the extreme prejudice inherent in statements concerning the matter at trial when made by an officer of the court specifically. Footnote 6. The Supreme Court did not apply the Rimmer analysis. In Parker v. Gladden, there, a bailiff who oversaw the sequestered jurors during an 8-day trial stated to a juror in the presence of other jurors, quote, "Oh, that wicked fellow, he is guilty." The bailiff also told another juror, quote, "If there is anything wrong in finding the petitioner guilty, the Supreme Court will correct it." At least one juror or alternate overheard the statements. In rejecting the state's argument that no prejudice was shown, the Supreme Court explained, quote, "This argument overlooks the fact that the official character of the bailiff as an officer of the court as well as the state, beyond question carries a great weight with the jury, which he had been shepherding for 8 days and nights." So remember, the person we're talking about here, Rebecca Hill, is the clerk of court, the person in charge of all of the jurors. She is an agent of the government because she is the clerk of court. Although the Supreme Court noted that 26-hour jury deliberations and one juror's testimony she was prejudiced also supported the trial court's finding of prejudice, it held, quote, "that the unauthorized conduct of the bailiff involves such a probability that prejudice will result that it is deemed inherently lacking in due process." It further recognized that it would be blinking reality not to recognize the extreme prejudice inherent in such statements that reached at least 3 members of the jury and 1 alternate member. However, not all comments by officers of the court are prejudicial. In Green, a juror asked the bailiff what would happen in the event of a deadlock, and he responded the judge would likely give them an Allen charge and ask if they could stay later. So what they're talking about here, an Allen charge, is where when a jury is deliberating and they can't reach a verdict, the judge can sit them down and basically tell them, "You're the best jury for this. You guys need to work this out, you know." I know what an Allen charge is, and I am somehow having so much trouble telling you what an Allen charge is. But it's basically a judge sitting down the jury and being like, "Now, children, now, children, I know you can come to an agreement. You are the best jury to reach this verdict. You were chosen specifically to reach this verdict. No jury after you will be any better equipped to reach this verdict. So please try to reach a verdict and, you know, in good faith, debate as much as you can and listen to each other and consider each other's perspectives." Thank you, Anala. But that's what an Allen charge is. While the Court of Appeals held the state overcame the Rimmer presumption, this court held the bailiff's comments did not trigger the presumption. We explained that our willingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. As the Fourth Circuit recognized, there is a split among the circuits regarding the issue whether the Rimmer presumption has survived intact following the Supreme Court's decisions in Smith v. Phillips and United States v. Olano. United States v. Lawson, that's quoted from United States v. Lawson, sorry. In Phillips, the Supreme Court declined to input bias to a juror who applied for a job in the prosecutor's office during Phillips' trial. In reversing the grant of the federal habeas relief, the Supreme Court declared, quote, that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. The court explained that, quote, due process does not require a new trial every time a juror has been placed in a potentially compromising situation. Instead, due process necessitates a jury capable and willing to decide the case solely on the evidence before it, and a trial judge ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. Hi, Shy Knight. Welcome. Thank you so much for finding me. Footnote 8. In both Phillips and Alano, the Supreme Court noted the case's procedural postures inform the outcomes. Of equal importance, this case is a federal habeas action in which the trial court's findings are presumptively correct under 28 U.S.C. section 2254 subsection D. Applying plain error standard because Alano does not object to the alternate juror's presence in the jury room. Alano 507 U.S. 736. The Court of Appeals should correct a plain, fortified error affecting the substantial rights if the error seriously affects the fairness, integrity, or public reputation of judicial proceedings. Howdy. Howdy. I like howdy. More people should use howdy as a greeting. In Alano, the Supreme Court considered whether the presence of alternate jurors during jury deliberations was a plain error that the Court of Appeals was authorized to correct under Federal Rule of Criminal Procedure 52 subsection B. Noting the alternate jurors' presence was not the type of error that affected substantial rights independent of its prejudicial impact, the court found no reason to presume prejudice. It explained, quote, there may be cases where an intrusion should be presumed prejudicial, but a presumption of prejudice as opposed to a specific analysis does not change the ultimate inquiry. Did the intrusion affect the jury's deliberations and thereby its verdict? Howder, Sanic! Sanic! I see your howdy and I raise you a howder. Neither Phillips nor Alano expressly overruled the Rimmer presumption. Indeed, in Alano, the court specifically recognized that prejudice should be presumed from certain intrusions, just not from alternate jurors who have been properly instructed not to deliberate, sitting in on deliberations of a jury. The Fourth Circuit rejected the argument that the Supreme Court overturned the Rimmer presumption of prejudice attached to extrajudicial communications with the jury, declaring the presumption remained alive and well in the Fourth Circuit. As a law school veteran, this sounds like the bloat they taught us in year one. We're going over the South Carolina Supreme Court's decision to reverse and remand on the Murdaugh trial. And going through the law is always, always so lovely. I should start skipping over the argument sections, but I find them so interesting. Where was I? There's so much in this one paragraph. While Phillips and Alano may somewhat limit the scope of presumptive prejudice, they do not preclude such a presumption in all situations, i.e., where excessive or egregious jury misconduct or improper contact by a third party occurs. No, don't skip, keep going? Okay, okay, I'll keep going. The Fourth Circuit explained the Rimmer presumption applies in cases where, quote, the danger is not one of jurors' impairment or predisposition, but rather the effects of an extraneous communication upon the deliberative process of the jury. Thus, the distinction between internal and external jury influences is critical because, unlike external influences which necessitate a thorough judicial inquiry, no such obligation is imposed with regard to an internal jury influence. There's so many parentheses in this paragraph. External jury influence on a jury involves situations where jurors receive information during deliberations from some outside source, while internal influence involves information coming from the jurors themselves. Remanding a remanding for a hearing when a juror was offered a bribe during trial and later was investigated by an FBI agent, which was Turner. It was either Turner or Rimmer. Okay, they're just explaining the cases here. I'm not going to go through all of that. I'm not going to go through all the parentheses. There's just a lot of them. Sanic, no, you're going to give me parenthesis PTSD. They have parentheses for the parentheses who wrote this. The South Carolina Supreme Court wrote this. Our decision in Green 2 did not derivate from Rimmer or its Fourth Circuit progeny. Adhering to Rimmer, we held that the facts of the case did not warrant applying the presumption, while leaving in place the Court of Appeals holding that the trial court must follow the Rimmer procedure when it learns of an allegedly improper contact with jurors. The Fourth Circuit has long recognized, quote, that certain kinds of extrajudicial contacts may amount to nothing more than innocuous interventions that simply could not justify a presumption of prejudicial effect. Remember, there's a difference in someone telling a juror, you know, oh, good morning, and someone telling a juror, watch their body language, they're obviously lying. And that's what we're talking about. We acknowledge that this court has not always employed the Rimmer presumption when considering external influences on the jury. In Kelly, an appellate asserted the trial court erred in denying his motion for mistrial when a capital case juror shared a pro-death penalty pamphlet in the jury room during the penalty phase of a trial. Because the appellant framed the issue on appeal as the denial of a mistrial, the court noted that, quote, in order to receive a mistrial, the defendant must show error in resulting prejudice, and held the appellant failed to show prejudice, which we did not discuss Rimmer. And, let's see. The penalty phase, that joke reminds me of the online news outlet website during the Amber Heard case where they put the parentheses backwards. What? I didn't even see that. Oh my gosh. I can't believe they put the parentheses backwards. Oh, we need to do the Depp v. Heard case sometimes, guys. We have to go look. We have to go look at that at some point. It was a wonderfully convoluted trial. Why does my phone keep ringing? To be fair, they fixed it within 2 days, but the fact that they did it at all. Anyway, so the difference in a penalty phase and a trial phase. It was very clear AI wrote it. Oh my gosh. But a penalty phase is where the penalty is being decided. So that's where especially in death penalty cases, it's where the jury deliberates on whether someone is getting the death penalty or whether they're getting something like life without the possibility of parole. So trials can have two distinct phases. But that doesn't apply here. That does not apply here. We had a one-phase trial, a sentencing the day after the verdict, and then we had a post-trial court reviewing a motion for new trial. Or a judge if people go that route, which is rare, yeah. In State v. Bryant, a death penalty appellant moved for a new trial after discovering detectives from the same police department as the victim contacted jurors' families after the jurors were death penalty qualified but before the jury was selected. This court held that, in cases where a juror's partiality is questioned after trial, it is appropriate to conduct a hearing in which the defendant has the opportunity to prove actual juror bias. We noted the detective's actions could have been perceived as an attempt to intimidate jurors and concluded that, given the nature of the case, the timing of the inquiries, and the questions which were asked, the jury could not have been fair and impartial. Thus, while we did not discuss Rimmer's rebuttable presumption, we essentially followed the procedure, recognizing that Rimmer and Phillips entitled the appellant to a hearing in which he had the initial burden of proving the detective's actions were more than innocuous interventions, and then rejecting the state's argument that the appellant was not prejudiced. Okay, and now we're getting to the meat of it. We're getting to essentially how the court is applying this to the current situation after they've discussed all the law. We clarify today that when faced with a third party's improper contact with a juror, the courts should follow the Fourth Circuit's three-set analysis set forth in Cheek, and 1. Require the defendant to meet the initial burden by presenting evidence that the contacts were more than innocuous interventions. 2. If this minimal standard is satisfied, recognize the Rimmer presumption is triggered automatically. And 3. Shift the burden to the prevailing party to prove that there exists no reasonable possibility that the jury's verdict was influenced by improper communication. Under this framework, we turn to the facts at hand. First, we must determine which comments Hill made to the jurors. The post-trial court referenced only a few of the comments the jurors testified she made. By example, quote, "This is an important day," or quote, "This is an epic day," and to watch Murdaugh's body language. The state argued the post-trial court implicitly rejected the other alleged comments as not being credible. We find this argument is without merit. Chilia, hello! Sheila. Is it how do you pronounce your name? How do you pronounce your name, friend? I'm bad at reading. Sometimes my dyscalculia becomes dyslexia. Which is funny because I read legal opinions for a living. I don't know what that emoji is, so I'm gonna go back to reading now. I'm gonna go back, okay? Okay. We find this argument is without merit. The post-trial court gave no indication it found the other comments not credible, nor would the record support such a finding. Indeed, the post-trial court found that Hill's denial of making any inappropriate comments lacked credibility. Footnote 10. Hill's lack of credibility during the hearing on Murdaugh's motion for new trial is further evidenced by her recent guilty plea to perjury stemming from the hearings of her denial of allowing members of the press to view sealed exhibits. Remember, she got arrested and pled guilty and got probation. The post-trial court made no distinction regarding the comments it referenced in its order and the remaining comments that are in the record. The post-trial court, in fact, found credible Jersey's affidavit statement concerning pressure from other jurors. The same affidavit included Jersey's recollection of Hill's comments, quote, "not to be fooled by the evidence presented by Murdaugh's attorneys," and Hill's instructions to, quote, "watch Murdaugh closely, look at his actions, and look at his movements." The state offers no rationale for finding part of the affidavit credible while rejecting the portions that were damaging to the state's case. Juror Z's recollection of Hill's comments were consistent with Juror 785's affidavit testimony that Hill told the jurors not to be fooled by the evidence Murdaugh's defense presented. Juror Z's recollection is also consistent with the alternate juror's testimony concerning Hill's comments. Quote, "They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off." These comments were also strikingly similar to comments Hill made to McElveen, other staff members, and media when away from the jury. Further, Hill's attempt To insert herself into the jury's deliberations through these comments was in line with her stated desire for a guilty verdict to sell more copies of a book she planned to write. Her meddling in events around Juror 785's dismissal, and her self-aggrandizing conduct throughout and after the trial, from granting favors to media members such as allowing them to view sealed exhibits, and sitting a writer with court staff in the courtroom to granting interviews. As the post-trial court found, quote, Hill was attracted by the siren call of celebrity and, quote, allowed her desire for the public attention of the moment to overcome her duty to oath of office. We have no reason to find Hill did not make all of the statements the jurors reported. Therefore, we hold Murdaugh established Hill made comments that the day Murdaugh testified was epic or important, and urged jurors to not be fooled, confused, thrown off, or convinced by Murdaugh, and to watch Murdaugh's body language closely. Such long-winded judges. I say that, but this is only 27 pages long. I've seen like 100-page long things. No, I'm not going to be reading any of those. I'm not going to be reading any of those. Only 27. I have seen worse. I have read worse. Not out loud, but like read to myself. My throat wouldn't handle. My throat couldn't handle that. And it can handle a lot of things, but it couldn't handle that. Next, we must decide whether these comments were more than innocuous interventions, and of such a character as to reasonably draw into question the integrity of the verdict. Hill's statements were more comparable to those of the bailiff in Parker than those of the bailiff in Green. Like the bailiff's statements in Parker, Hill's comments attacked the defendant's character and credibility, which certainly were matters before the jury. Hill became a character witness on behalf of the state, encouraging the jurors to question Murdaugh's credibility. In fact, by urging the jurors not to be fooled or convinced by Murdaugh's defense, Hill essentially implored the jurors to find him guilty, the ultimate issue in this case. Even Hill's seemingly innocuous comments that the day Murdaugh testified was epic or important became nefarious when considered with her other comments, insinuating that there was something unusual or suspicious about his decision to testify. In contrast, the bailiff's statements in Green, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. Therefore, we hold Murdaugh met the minimal standard of showing that the extrajudicial communications or contacts have more than innocuous interventions. And the post-trial court erred as a matter of law in refusing to impose the Rimmer presumption. What's with the question marks, wee? What's with the question marks? What? You got something to say? Our following consideration is whether the state met its heavy burden of providing there is no reasonable possibility that the verdict was affected by Hill's comments. As stated above, the post-trial court analyzed the evidence before it by erroneously imposing the burden of proof of prejudice on Murdaugh. Furthermore, as Murdaugh argues, the post-trial court erred in considering testimony from the jurors about whether Hill's comments affected their verdict because this testimony violated Rule 606, subsection B of the South Carolina Rules of Evidence. I mean, take that how you will. Take it however you want. Rule 606B, SCRE, South Carolina Rules of Evidence, limits the testimony a juror may give on the issue of prejudice. This rule provides, upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the juror's deliberations or to that effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment, or concerning the juror's mental process in connection therewith, except that a juror may testify on the question whether extraneous prejudicial information was improperly brought to the jury's attention and whether any outside influence was improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. So essentially, you can't ask about deliberations. Deliberations are like sacred. You can't ask how a jury came to a verdict, why a jury came to a verdict, or how their deliberations went. It is completely improper. So by asking the juror, by the post-trial court asking the juror, how the deliberations went, whether they were more influenced by the other jurors during deliberation or Hill's comments, that was improper. In interpreting the court rules, this court applies the same rules of construction used to interpret statutes. Thus, if a rule's language is plain, unambiguous, and conveys a clear meaning, interpretation is unnecessary and the stated meaning should be enforced. We must consider not only the particular clause in which the word may be used, but the word and its meaning in conjunction with the purpose of the whole rule and the policy of the rule. In addition, when a South Carolina rule is substantially the same as its federal counterpart, we may consider federal cases in interpreting the rule. The United States Supreme Court explained Federal Rule of Evidence 606 subsection B. Our Rule 606 subsection B's federal counterpart is grounded in the common law rule against admissions of jury testimony to impeach a verdict and the exception for juror testimony relating to extraneous influences. In Tanner, the Supreme Court examined the legislative history of Federal Rule of Evidence 606 subsection B, setting forth the rationale for the rule. Public policy requires a finality to litigation, and common fairness requires that the absolute privacy be preserved for jurors who engage in the full and free debate necessary to the attainment of just verdicts. Jurors will not be able to function effectively if their deliberations are to be scrutinized in post-trial litigation. In the interest of protecting the jury system and the citizens who make it work, Rule 606 should not permit any inquiry into the internal deliberations of the jurors. Are we almost done with this section? No. Yes. No. Yes. No. No, we're not. The Supreme Court noted its holdings requiring an evidentiary hearing where extrinsic influence or relationships have tainted the deliberations do not detract from, but rather harmonize with, the weighty government interest in insulating the jury's deliberative process. Thus, while a probing factual inquiry is not only permissible but necessary when a third party makes extrajudicial comment with a juror, the rule prohibiting all inquiry into a juror's mental process in connection with the verdict. The Fourth Circuit noted that, by asking a juror whether he had listened to and considered all the evidence, the government was delving into the juror's mental process about the sufficiency of the evidence in reaching his personal verdict. Such an inquiry exceeds the strict limitations imposed by 606 subsection B. It further held that the district court erred by relying on the juror's mental process in connection with the verdict when formulating its findings of fact. We find that the plain language of Rule 606B SCRE authorizes jurors to testify about improper extraneous comments by a third party, but do not on the comments' effect on the juror's deliberative process. While, as the Fourth Circuit recognized, Rule 606B at times makes it more difficult to determine whether a new trial is warranted, sound policy supports the rule and outweighs any convenience or difficulty the rule imposes. The state must meet its burden of rebutting the Rimmer presumption without exceeding the limitations of the rule. We, therefore, hold that the post-trial court erred in questioning the jurors about whether Hill's comments influenced their verdicts and in relying on the jurors' answers in its prejudice analysis. The state contended Murdaugh cannot complain about the post-trial court questioning Jersey's regarding her affidavit because Murdaugh submitted the affidavit to the post-trial court with his motion for new trial. We disagree. The purpose of Rule 606 subsection B is to preserve the sanctity of the jury room, protecting the jury system and the citizens who make it work. This right was not Murdaugh's to waive. Thus, the portion of Jersey's affidavit in which she disclosed her mental process in reaching the verdict is inadmissible. Oh, there was a footnote in there somewhere that I missed. Footnote 12. We recognize that in Ethier, this court held the affidavits and testimony from the jurors describing whether another juror's premature deliberations affected their votes were admissible because premature deliberations may affect the fundamental fairness of the trial. We hereby overrule Ethier to the extent this case condoned the use of testimony about the juror's mental process in reaching their verdict. The post-trial court erred in questioning her about that portion of the affidavit, and the post-trial court should not have considered that portion in ruling on the new trial motion. I have to keep drinking water. I'm so thirsty. Let me see if I can make this a little bigger. Yes! There we go. We also hold the I can't talk. Hydration is important. Yes, hydration is very important. Make sure you are hydrated. Every time I hydrate, you must also hydrate. We also hold the post-trial court erred in finding a lack of prejudice because Hill's comments were limited in subject and not overt as to opinion, were only heard by at most 3 jurors, and were made in a case with overwhelming and compelling evidence. We reiterate the burden is on the state to rebut the presumption of prejudice. First, the post-trial court erred in finding Hill's comments were limited in subject and not overt as to opinion. Hill clearly advised the jurors to find Murdaugh in the evidence he presented not credible and, essentially, urged them to render a guilty verdict. Hill's position as to the Colton County Clerk of Court, an officer of this court who managed the trial and was the primary caretaker of the jury, amplified the impact of Hill's comments had on the jury. Next, the limited number of jurors who acknowledged hearing Hill's improper comments did not reduce their prejudicial effect. As the Supreme Court explained, a criminal defendant is entitled to be tried by 12, not 9, or even 10 impartial and unprejudiced jurors. In addition, in the context of a jury tainted by external influences, the strength of the state's case does not necessarily warrant a finding that the state met its burden in proving a lack of prejudice. The state certainly produced considerable evidence here, and, arguably, reasonable minds may debate whether the evidence here was overwhelming. In the situation before us, notwithstanding the strength of the prosecution's case, the state is unable to overcome the presumption of prejudice. The state's case rested largely on circumstantial evidence, and Murdaugh's credibility was a key component of his defense. Hill's repeated comments challenging Murdaugh's credibility directly undermined that defense. Hill's egregious, improper jury interference went to the heart of the case and unquestionably was intended to push the jury to a guilty verdict. Basically, you can have a case where they go to trial and the defendant has walked into the police station and held out their hands for the handcuffs and said, "I did it, take me away." And they go to trial. If someone improperly influences the jury, that doesn't matter that the state's case is so rock solid. It doesn't matter that they said, "Take me away, I did it," you know? What matters is whether the jury was influenced more to a guilty verdict than a not guilty verdict by someone else. the breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina. She wanted fame. She wanted notoriety, and damn is she getting it. She will live in the legal canon forever. She got what she wanted. Finally, we hold the state has not met its burden of proving the trial court's instructions to the jury cured any prejudice arising from Hill's comments. Generally, an instruction to disregard incompetent evidence is deemed to have cured the error. Moreover, jurors are presumed to follow the law as instructed to them. Here, the trial court gave the standard instructions and admonishments to the jury, none of which provided guidance on what to do when the Colleton County Clerk of Court, an officer of the court, made comments disparaging Murdaugh's credibility and urging the jury to reject his defense. The trial court never had the opportunity to even attempt to cure the prejudicial effect on Hill's comments because they did not come to light until months after the trial. The monkey paw girls. If we were to accept... Oh my god, it's 6:30 and I'm already yawning. I can't. If we were to accept the proposition that the standard charges could cure such prejudice, then no defendant would be entitled to relief when improper extrajudicial information reaches the jury's ears, regardless of its content or context. Our federal and state constitutions simply cannot countenance such an assault on the right of a fair and impartial jury. Don't wow me, Sanic. Don't wow me. In summation, Murdaugh met his initial burden of establishing Hill's comments to the jury were more than innocuous interventions, triggering the Rimmer presumption of prejudice and shifting the burden to the state. The state simply was unable to meet this heavy burden of proving that there exists no reasonable possibility that the jury's verdict was influenced by these highly inappropriate comments. Accordingly, we hold Murdaugh's right to a fair trial by an impartial jury was violated, and the post-trial court erred in denying his motion for a new trial. Subsection B. Evidence of Murdaugh's financial crimes. Because we order a new trial on the basis of Hill's improper influence on the jury, on the appeal from the order denying motion... Let me start over. Because we order a new trial on the basis of Hill's improper influence on the jury, on appeal from the order denying Murdaugh's motion for new trial, it is not necessary that we address the evidentiary issues Murdaugh raises on appeal from his convictions and sentences. We elect, however, to offer the trial court on remand the following guidance regarding the admissibility of evidence of Murdaugh's financial crimes. Footnote 13. In addition to Murdaugh's challenge to the court's decision to admit evidence of his financial crimes, Murdaugh appealed the trial court's decision to 1. Allow the state to question a witness on redirect examination about the witness's knowledge of Murdaugh's financial crimes, 2. Admit evidence of firearm and tool mark analysis expert testimony, 3. Admit evidence of 4 firearms seized from Moselle. Moselle was the location of the murder. 4. Admit evidence of a blue raincoat collected from the home of Murdaugh's mother and gunshot residue expert testimony related to that raincoat. 5. Allow the state to question Murdaugh on cross-examination as to the reason he did not reveal until trial his presence at the kennels on the night of the murders. And 6. Admit evidence of an iPhone demonstration during the state's rebuttal case. All that to say, that's the stuff they're not looking at. They're only looking at the admissibility of the financial crimes. And not in a ruling way, but in a way to provide guidance for the retrial. Oh, I'm so getting an ice cream after I get done reading this. At the time of the trial, Murdaugh had been accused of and indicted for numerous financial crimes. During his testimony before the jury, Murdaugh admitted he committed the financial crimes, although he had not at the time been convicted of anything. After trial, he pled guilty to the financial crimes in both state and federal court. He was sentenced to concurrent 27 years in state prison and 40 years in federal prison. Remember, we talked about this the other night, the difference between consecutive and concurrent. Consecutive means one after the other, 27 plus 40. Concurrent means at the same time, 27 served at the same time as the 40, so 40 years is what he'd serve. The state sought to admit evidence of these financial crimes during Murdaugh's murder trial for the purpose of showing his motive for committing the murders. The state filed a pretrial motion in which it argued the evidence demonstrated Murdaugh accrued substantial debts over a period of years, and to cover those debts, began engaging in illicit financial crimes involving theft and misappropriation of money from his clients and his own firm. The state emphasized that several series of events unfolding in the weeks and days leading up to the murders threatened to expose Murdaugh's financial crimes. The state wrote in its motion, "All of these factors start to converge on June 7, 2021, the date of the murders. The state explained its motive theory. These murders served as Murdaugh's means to shift the focus away from himself and buy himself some additional time to try to prevent his financial crimes from being uncovered. The state also stressed Murdaugh's attempts to cover his financial misdeeds after the murders to support its theory of motive." Hi, Exotic Fox. Welcome in. Thank you for joining us. Murdaugh filed a memorandum arguing the financial crimes evidence should be excluded under Rules 402, 403, and 404B. The trial court conducted a lengthy pretrial hearing, but declined to rule on the admissibility of the financial crimes evidence at this time. During various breaks in the course of the trial, the state presented the testimony of 8 witnesses regarding Murdaugh's financial crimes outside the presence of the jury. After hearing this testimony and the arguments of both sides, the trial court found, quote, "All evidence of financial crimes that may likely have led to a motive or lend itself to motive for the crime committed was admissible." The trial court stated the jury was, quote, "entitled to consider whether the apparent desperation of Mr. Murdaugh, because of his dire financial situation, threat of being exposed for committing the crimes for which he was later charged with, resulted in the commission of the alleged crimes." The trial court also found this evidence of other crimes is admissible and its non-propensity, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground than the specific charge. The trial court found the evidence had sufficient probative value that was not substantially outweighed by any danger or unfair prejudice. The trial court issued a written order setting forth its ruling. The state then presented testimony to the jury from the 8 witnesses who testified, along with 2 additional witnesses. Footnote 14. Footnote 14 is just going over who those 8 witnesses, 10 witnesses were, and I'm not going to read that. Through these witnesses, the state proved Murdaugh committed wide-ranging financial crimes over numerous years in several general categories, including the following. 1. Murdaugh stole money from his clients by billing personal expenses to them under the guise of those expenses being costs associated with their cases. 2. Murdaugh stole money from his law firm by instructing law firm employees to make checks payable to Palmetto State Bank, whose then chief executive officer, Russell Lafitte, enabled Murdaugh to convert the funds for his personal use. 3. Murdaugh stole money from his clients and his law firm by instructing law firm employees to make checks payable to Forge, a fake account Murdaugh created to imitate the legitimate Forge Consulting LLC firm that Murdaugh then deposited and used for personal expenses. And 4. Murdaugh stole money from Tony Satterfield by filing an insurance claim in relation to his mother, Gloria Satterfield's death, and collecting the insurance proceeds for personal use instead of providing the proceeds to Tony and Gloria's other son. The state also presented evidence to the jury that Murdaugh's years of stealing money in these ways were about to be exposed. For example, law firm employees testified they asked Murdaugh on at least 2 occasions in the weeks leading up to the murders about discrepancies in his financial disbursement documents in the individual cases. Jeanne Seckinger, the firm's chief financial officer, testified she confronted Murdaugh on the morning of the murders, stating, quote, "I have reason to believe that you received attorney's fees in a certain case directly to you, and you need to prove to me that you did not." Other evidence indicated Seckinger was referring to $792,000 in missing attorney's fees the firm was supposed to receive from Murdaugh's co-counsel Chris Wilson. The state also presented evidence that Mark Tinsley, the attorney representing the family of the young woman who died in the boat wreck, had scheduled a motion hearing for 3 days after the murders in which Tinsley sought to compel Murdaugh to disclose his detailed financial records. Murdaugh challenges the admissibility of evidence of his financial crimes under Rules 401, 402, 403, and 404B. As to Murdaugh's relevance objections, the state argues that because Murdaugh was charged with murdering his wife and son, seemingly inexplicable conduct when standing alone, it was important that it offer evidence to explain why he did it. The state also argues Murdaugh himself placed the issue of motive in front and center through his own actions by suggesting to officers who arrived at Moselle on June 7th that the killer's motives stem from the boat wreck. We agree that that evidence of Murdaugh's financial crimes made the state's theory of motive more probable. Thus, we find that the trial court acted within its discretion in finding the financial crimes evidence was relevant under Rules 401 and admissible under Rule 402. The more difficult question is whether the trial court should have excluded all or some of the financial crimes evidence pursuant to Rule 404B or Rule 403. We address this question as 2 distinct categories of issues. The first of these categories, whether the trial court should have excluded all the financial crimes evidence, is a point on which not all the members of the court would have ruled the same way had we been the trial court. Like I said, this is a panel of judges, not just one. We each agree, however, that this decision was within the discretion of the trial court under the facts and circumstances that existed in Murdaugh's trial. As to the second category, we will address whether the trial court should have restricted the extent to which the state was allowed to present this evidence, that is, whether the trial court should have excluded some of the evidence. We unanimously hold that the trial court allowed the state to go far too long and far too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory of motive, which gave rise to considerable danger of unfair prejudice and therefore should have been excluded. As to whether the trial court should have excluded all evidence of Murdaugh's financial crimes under 403 and 404B, we have discussed the principles applicable when a trial court is asked to exclude evidence of other crimes in numerous cases, and no further elaboration of those principles is necessary here. That is a paragraph of entirely citations. Okay. As to Rule 404B, the difficulty lies in the application of these principles to the facts and circumstances of any individual case. Here, the trial court correctly understood the applicable principles of law and thoughtfully applied those principles to the facts and circumstances before it. The trial court examined its view of the logical connection between the financial crimes and Murdaugh's motive. The state's argument that it presented a valid theory of motive and Murdaugh's response that the fabricated motive theory is illogical, implausible, and not supported by evidence was not a dispute for the trial court to resolve by making this evidentiary ruling. That was for the jury. The trial court's job was to determine in its discretion whether the state's theory of motive was reasonably plausible, and if so, whether the evidence the state presented could reasonably support the theory. We agree with the state that, under the facts and circumstances in existence in Murdaugh's first trial, the court acted within its discretion in deciding not to exclude the evidence under Rule 404B. Minnie is busy reading court crimes. I am busy reading court crimes. Oh, crime courts, not court crimes. Yes, the court did not commit crimes. Well, technically the court did commit crimes because Becky Hill is an officer of the court, so the court did in fact commit crimes. GG court. As to Rule 403, the trial court balanced the probative value of the evidence against its potential for unfair prejudice and concluded the probative value was not substantially weighed by any unfair prejudice. The trial court specifically found Murdaugh's commission of the financial crimes does not suggest to the jury that the defendant has a tendency to commit murder. As we will discuss below, we find considerable unfair prejudice in allowing the state to go as far and deep into detail as it did. However, we hold the trial court acted within its discretion in admitting some... Oh god, my microphone. I'm sorry. I'm sorry for your ears. Some evidence of Murdaugh's financial crimes. We emphasize, however, the trial court should have limited the state's presentation of the evidence. We illustrate this point with an example from the direct examination of Tony Satterfield. State: why were you the personal representative and not your brother? Satterfield: because my brother is a vulnerable adult and he has a disability. Court: can you repeat those words for me? Satterfield: that my brother, he's a vulnerable adult and he's not able to function as a normal human being to deal with stuff like that. State: he is a vulnerable adult? Satterfield: yes. This particular testimony... I heard nothing in particular. It's fine, Minnie. Okay, good. Okay. At least my chat heard nothing. Apologies to the YouTubes later for the VOD. This particular testimony had zero probative value as to Murdaugh's motive for the murders and obviously high potential for unfair prejudice as it portrays Murdaugh as a man who preys upon vulnerable victims. Much of the additional detail the state presented as to Murdaugh's financial crimes had little or no probative value for the purpose of establishing Murdaugh's motives. The state's theory of motive centers the point that his financial crimes were about to be exposed and he needed time. The fact he committed some of those crimes against a vulnerable adult adds nothing to the theory. To the extent many similar details may have had minimal probative value, that value is substantially outweighed by the unfairly prejudicial sympathy the jury was likely to feel towards this victim. By our calculation, the state spent a total of 12.5 hours of actual testimony before the jury, over 10 days of trial, to introduce evidence related to Murdaugh's financial crimes. We are convinced the state could have effectively presented evidence to support this motive theory in a fraction of that time. By holding the trial court in this case acted within its discretion in admitting some evidence of Murdaugh's financial crimes, we certainly do not intend to require the evidence be admitted on retrial. As is often the case, the facts and circumstances on retrial may be materially different from those presented in the initial trial. Thus, the trial court on remand must do as the trial court did here, carefully and thoughtfully apply correct principles of law to the facts and circumstances before it. We do intend to require, however, that if the trial court decides to admit evidence of Murdaugh's financial crimes on retrial, the state must complete its introduction of that evidence efficiently without the lengthy presentation of inflammatory details with little to no probative value that was permitted in the first trial. Conclusion. We're finally at the end. This is the very last paragraph. As the Fourth Circuit declared, the Rimmer presumption is alive and well. It serves to protect the right to a fair trial by an impartial jury for all defendants. Here, Hill, the Colton County Clerk of Court, egregiously attacked Murdaugh's credibility and his defense, thus triggering the presumption of prejudice, which the state was unable to rebut. As noted at the outset, Hill's shocking jury interference was accomplished outside the presence and knowledge of the outstanding trial judge and superbly competent and professional counsel for the state and the defense. We are accordingly constrained to reverse the post-trial court's denial of Murdaugh's motion and remand for a new trial consistent with this opinion. We commend the post-trial court, Justice Toll, which inherited Murdaugh's motion for a new trial and was placed in the unenviable position of evaluating unprecedented jury interference by a clerk of court within the context of a murky area of law. And that is the ruling. That is the ruling. So, what does all that mean? What does all that mean? It means when something is reversed, it means that the Supreme Court, or the higher court, in this case the Supreme Court, has overturned a decision made by a lower court. Here we're talking about the post-trial court, Justice Toll, denying the motion for new trial. So that was reversed, meaning that the motion for new trial is granted and Murdaugh gets a new trial. Remanded means it is sent back to the lower court. So it will go back to the original court jurisdiction in the sense that when it does have a new trial, it will be before the original court. They say nothing about recusing the original judge. They don't talk... something to understand is that when there are errors of law, that does not mean errors of people. It means that they held something that doesn't quite jive with the legal precedents of the time. And especially in this situation where, like they said in the last bit, it was an incredibly murky area of law. Because South Carolina's statute was different from the federal Remmer statute, which a lot of other places will have similar statutes to the federal statute. I get it now. I'm so glad you get it now. So a lot of reason that that the Supreme Court will take up something is that there needs to be a change or a clarification in the law, like we see here. Because the area of law was murky, the Supreme Court took the opportunity to clarify it and to bring South Carolina in line with the federal Remmer standard. So, where do we go from here? Well, the Attorney General of South Carolina has said that while they still have time to appeal, because they can appeal this decision within 15 days, and they can take it to the Superior Court of the United States within 90 days, but they've said they're looking at moving very quickly with a retrial. So, for all intents and purposes, they're going to be retrying this case, and they want to do it before the end of the year. The defense has said essentially the same thing. We're going back to trial. There will be no discussion of a plea, nothing like that. This is going to go to a second trial. It will be interesting to see, based on the decision of the higher court, how that trial goes. We've already seen that they've said if the state does present this evidence of financial crimes, they have to do it quickly and succinctly, and not like they did at the last trial. So we know if the financial crimes come in again, which this court has said they were correctly brought in, just incorrectly implemented. So it'll be likely that they will come in again if that door is opened. Because the door had to be opened for the evidence to come in the first trial. So it'll be interesting to see exactly how this goes. I'm very, very excited. I'm very interested to to watch the upcoming trial. Which is gonna suck, because when this originally went to trial, I had a job where I could listen to it on my phone all day, because that's what I do for fun, is I listen to trials. But I don't have a job where I can do that anymore, so it means I'll have to wait till I get off work to be able to talk about it. Ah! I'm so distraught. I am so distraught. But anyway, all that said, I am looking forward to it. I hope you guys, simply how it is, yet that's simply how it is. But yes, so I am looking forward to going through it with you guys too. And let's see. I'm gonna end this stream. I'm gonna go get some ice cream. I'm gonna end this stream and we're gonna switch over to playing some video games. But I don't want to keep it on this stream because this one, like, I can't change the title midstream. I can't change the title midstream. So I'm going to switch over. I'm going to take a quick break. I'm going to get some ice cream, and then we will definitely be coming back and playing some more Neverness to Everness. So I will see you guys in a few minutes. I will catch you in a bit. Thank you so much, and I will see you soon. Bye-bye. And where's my OBS? There's my OBS.